It took almost 2 years since the release of the draft bill for the Mediation Act to come into existence. Let us have a look at the 10 things you should know about the Act. First, it consolidates the law on mediation in India. It overrides, it amends, and it even subsumes other laws subject to a few exceptions. It goes on to define mediation, explain types of mediation, and also settle the mediation-conciliation battle. Secondly, it recognizes party autonomy as the paramount feature of mediation. The parties are free to commence or not commence mediation. The parties are free to decide the place, language, and mode of mediation or opt for the default mechanism. The parties are free to continue with or withdraw from mediation proceedings. And most importantly, the parties have the right to self-determination. They are free to settle or not settle their disputes. Thirdly, it sets out a facilitative role for courts. Amongst others, the courts have the power to refer the parties to mediation at any stage of the proceedings before it. The courts may order suitable interim relief, at least in certain cases. The courts, of critical importance, have the power to deal with the applications for the enforcement or challenge of mediated settlement agreements. Fourthly, it explains the test of non-mediatability. The Act provides an indicative list of matters or disputes that are not fit for mediation. Fifthly, it ensures proper, smooth, and timely conduct of mediation. The Act provides a strict time limit to complete mediation. It lays down the manner of conduct of mediation and sets the role of mediators. It gives a lot of confidence and protection to the mediating parties through the confidentiality and non-disclosure provisions. Sixthly, it makes mediated settlement agreements final and binding and enforceable as a judgment or decree of court. The Act thus addresses one of the fundamental grievances against mediation regarding the difficulty in enforcing its outcome. A challenge may be made against the settlement agreement, but the Act prevents the parties from making indiscriminate challenges by imposing substantive and procedural restrictions. Seventhly, it establishes the Mediation Council of India to promote mediation in India. The Council effectively creates a national mediation network and brings the much needed professionalism into mediation. Eighthly, it recognizes mediation agreements but leaves them toothless. Mediation agreements are defined and some formal requirements are prescribed by the Act, which is good, but there is no specific consequence for breach or non-compliance, which is not good. Ninthly, it makes no mention of the Singapore Convention on Mediation. There are no provisions for the enforcement of the Convention settlement agreements. Being a signatory to the Convention, we will eventually provide for the enforcement of the Convention settlement agreements, but for the time being, leaving the Convention out of the Act goes down as a missed opportunity. Finally, it creates confusion by retaining the idea of pre-litigation mediation. It appears as if the drafters are too fixated on the idea of pre-litigation mediation, although they have made it optional. So in conclusion, there are shortcomings, there is a long way to go, but the Act is definitely a good start as far as mediation in India is concerned.